I'm Drew Stevenson, and this is a video for my professional responsibility class about Model Rule 1.5, lawyer fees and legal ethics. And this is part 6 in my little series of videos about legal fees. And here we're talking about a fairly recent ABA ethics opinion that pertains to referral fees. And we mentioned this earlier in the course, I believe, when we were talking about conflicts of interest. So this is from 2016, and it's Ethics Opinion 474. Now, it starts out that remember that Rule 1.5e allows lawyers who are not in the same firm to divide a fee under certain circumstances. So imagine that multiple firms work together on a very complex case. That's possible, or at different phases of the case. So you have one firm that does the trial and another firm that does the appeal, hypothetically. And so the 1.5e sets out the client has to consent and be informed, and the payment to each lawyer has to be in proportion to the work they did, or each lawyer, if they're getting paid more than the work they did, they have to assume joint and several liability basically for the entire matter if there's a malpractice action. But let's talk about the case where you have a lawyer who's basically has a business model where they advertise heavily to invest a lot in advertising to sign up new clients, and then they don't actually do the case. So they do an initial workup or assessment of the case to make sure it has merit, and then they refer it to another firm to actually do the litigation for the case in exchange for a referral fee. Well, if you do that, if you refer a matter to another lawyer outside the first lawyer's firm, and then you divide a fee from the matter with the lawyer to whom the matter has been referred, you have undertaken representation of the client. In other words, you did some sort of signing up of the client and then referring the case out. So that person was a client, and that triggers the conflicts of interest rules and potential for legal malpractice actions. Remember that fee arrangements under Model Rule 1.5e are subject to Rule 1.7. So if you have a conflict of interest, that's going to come up and become an issue when you try to get a referral fee. And so let's talk about the situation where you have a client come in for a consultation, and you realize either during the consultation or after they leave and you do your conflict screening that you can't represent them because you have a conflict of interest. And so you refer the fee to another firm. Well, if you do that, that's fine, and you should do that, but the other firm can't then pay you some sort of portion, even a small portion of the recovery or the fees that they get from that client, as sort of a thank you for the referral. In other words, you may not accept a fee when the lawyer has a conflict of interest that prohibits the lawyer from either performing legal services in connection with it or assuming joint responsibility. If you couldn't represent the person yourself because you have a conflict, you can't get a referral fee in that case either, unless the client gives informed consent confirmed in writing pursuant to 1.7. So if the client says, I don't care about the conflict and I want the first lawyer I talked to who did no work on the case and just referred me out to get a referral fee, if they understand what that means and what the conflict is and they confirm it in writing, that's okay. But if they don't do that and you refer the case out because you couldn't represent the person, you cannot accept a fee in that case. Now, even if you don't accept a fee or get a fee, remember that the other firm could thank you. They could take you out to lunch. They could send you a fruit basket for the referral, something like that. That's just a nice gesture, but not a portion of the fee that they actually get from the client. And that concludes our lecture about connecting ABA Ethics Opinion 474 to Model Rule 1.5 and legal fees.